Hello, everyone. Good afternoon. My name is Carmel Sheffer, and I'm the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. We are delighted for you to join our event, Incarcerated Populations and COVID-19. This event will last about an hour. A few housekeeping things. If you like this event, we have a whole host of other events that will be happening throughout the summer, some of which are already on our website. You'll be hearing about them momentarily. We encourage you to sign up for them. We also have a newsletter that goes out twice a month. We avoid spamming your inbox, and you can, again, sign up for that newsletter by going to our website. It's the best way to find out when we announce an event. Having said that, I'm going to turn the floor over to our moderator for today, Stephen Wood, who is a fellow in bioethics at the Center for Bioethics at Harvard Medical School, as well as a visiting scholar at the Petrie-Flom Center. Stephen, take it away.
Thank you, Carmel. So again, we're delighted to have you all here today for our discussion on incarcerated populations and COVID-19, the public health, ethical, and legal concerns. As you're all aware, and I'm sure the reason you're joining us here today, prisons, jails, and detention centers are at incredibly high risk for disseminating the SARS-CoV-2 virus, which is the virus that causes the disease known as COVID-19. Some prisons have estimated that approximately 70% of their population has COVID-19. And as we all know, social distancing is difficult, if not impossible, in this setting, and therefore exposure is very, very high. And oftentimes some of the protections that have been put in place often serve to further isolate prisoners and put restrictions on activity, visitation, and even opportunity for legal counseling. In response to this, some areas have released inmates and detainees, but this is really has not been a consistent program. And so this panel today will explore the unique public health challenges of managing COVID-19 in detention centers and future epidemics or pandemics in how they affect the penal system. We'll discuss recent litigation, and we'll consider the ethical obligations to incarcerated individuals during epidemics and pandemics. Just to kind of reiterate a few of the housekeeping items, we are not going to have a live Q&A, but we do have a very lively Twitter account that's being monitored by several of us. And so if you want to join that conversation, we welcome you to join using hashtag COVID in prison. So that's COVID IN prisons. And you can also follow the Petrie-Flom Center at Petrie-Flom. We'll monitor that throughout, and we'll put some questions up from Twitter onto our Q&A panel. We also have, again, a series of events at Petrie-Flom coming up on tomorrow, May 21st at 5 p.m. There'll be discussion on pandemic resilience in schools, and you can access that through the website. And similarly, on June 2nd, there'll be a program on data in COVID-19. Again, all of these are accessible through the Petrie-Flom website. And you can visit that at petrieflom.law.harvard.edu. Again, the newsletter is a great way to keep informed. If you go to the website, scroll down to the bottom of the page, it's a simple click to subscribe. We also hope, again, that you follow us on Twitter at Petrie-Flom. So with that, let me introduce our panel. We have a great panel today. First, we have Jesse Rossman, an attorney with the Massachusetts ACLU and the 2015 National Law Journal Rising Star recipient. Jesse is an advocate for a broad range of civil rights issues and has been working with the Mass ACLU since 2013. Next, we have Dr. Kartik Sivashankar. He is an assistant professor of psychiatry at the Boston University School of Medicine. He's also the medical director of quality, safety, and equity at the Brigham and Women's Hospital here in Boston, and a clinical innovation scholar at the Institute for Healthcare Improvement. And we also have Joel Thompson, the managing attorney at the Harvard Prison Legal Assistance Project, and a former attorney at the Prison Legal Services of Massachusetts. So I don't want to take up any more of their time. Without further ado, I'm going to welcome our first panelist, Jesse Rossman, to kick off our event.
Thanks so much, and I'm really excited to be here virtually with you all. As we were mentioning at the beginning of the panel, we know that congregate settings are one of the areas in which we need to be particularly aware and diligent against the spread of COVID-19. We've seen that in nursing homes, we've seen that in cruise ships, and we've also seen that in jails and prisons. And as a result of that, very quickly after the pandemic hit, advocates, and I use that term very broadly, attorneys, public health scholars, organizers really jumped into action to see and make sure that we were going to be able to take some action to protect individuals who are held in the custody of the state. And I think the numbers are really striking. I just want to start out at the very beginning to say we know that this is something that really, when there's an outbreak at jails and prisons, it can spread extraordinarily rapidly. Right now, California had been lobbying to ensure that the Lompoc Institute, which is one of the Bureau of Prisons facilities in California that has one of the highest outbreaks of all Bureau of Prisons facilities throughout the country, that it was not counted in its state count so that it could actually move to the next phase of reopening. That is the degree to which these numbers really can have an impact, not just on the individuals on the inside, but also on the people who work there, their family members, and the surrounding communities. So there have been a number of different responses in terms of how people have addressed this and how communities have addressed this within the past 2.5 months. For example, in Kentucky, the governor commuted the sentences of over 900 individuals who were serving state and county sentences in the state. In New Jersey, there was a coalition of individuals from all of the different aisles. You had the ACLU, public defenders, the Attorney General's office, and the district attorney's offices all came together to reach a consent decree that was filed in the court that ensured that individuals who were being held on probation violations or because they had been convicted in the municipal court, which generally indicates that it is a charge that had a lesser sentence, would be released. But as is sometimes the case, a lot of the action right now in this area has been in litigation in both state courts and in federal courts. The ACLU is an organization, and this includes both affiliates throughout the country as well as our national office itself, has brought 47 legal actions in jails and prisons. These are both class actions and individual habeas petitions for individuals who are incarcerated. That doesn't include the number of actions that have been brought by other organizations and other members of the bar who have jumped in to help protect those who are incarcerated. And it also doesn't include in that count the number of cases that have been filed for individuals who are being held in immigration detention. And those individuals are often being held in places like houses of corrections. Right here in Massachusetts, for example, we do have immigrant detainees at some of our county facilities as well. And the general theory in most of these cases is that it violates the 8th Amendment, the federal Constitution's 8th Amendment, or the state counterpart, which essentially sets out that when you as a state are holding someone in custody against their will, there are certain responsibilities that you have because they are unable to do things on their own. And that includes a constitutional responsibility to provide adequate medical care. And in order to bring a claim under the 8th Amendment, you need to show that there's a serious medical need or a serious medical risk. In most of these cases, that has not been challenged when we're talking about the pandemic. And you also need to show that there's deliberate indifference on the part of the institution to fail to protect people from that risk. And so when we talk about deliberate indifference, that's really looking at what are the steps that the institution has and has not taken, and how can you show that there was actual indifference on the part of an institution to fail to protect them from this serious risk. Again, because they're unable to do so for themselves. Some of the factors that come up in these cases focus on some of the conditions within the facility. So that's looking at the inaccessibility of hygiene products, whether or not there are sufficient masks and other protective equipment that are being provided both to staff members and to the prisoners, education within the facility to ensure that people understand the spread of the disease and what they can do to help protect themselves. But I think there are really 3 critical areas that much of the litigation has focused on, and that is first, the inability to practice social distancing at the current population levels at these facilities. And that transcends a whole host of different activities. That goes from sleeping to recreating to eating to using the bathroom. And again, in many of these areas, if there's not constant cleaning, we know that the virus lives on surfaces upwards of 3 days, depending on the actual surface itself. So the population right now, and getting that down to a level that can protect both the individuals who are being released, as well as the individuals who remain in the institution so that they can actually effectively practice social distancing, has been critical. A second component of these cases has looked at testing, or the lack thereof. As you know, we now understand that this virus, the vast majority of individuals, or at least a significant percentage of individuals, will either be asymptomatic, even though they carry the virus, or be pre-symptomatic. So a period of time of 1 to 2 days when they are actually infectious, but are not yet displaying any symptoms. And for that reason, practices that focus on trying to screen either staff members or individuals who are housed at these institutions solely based on symptoms, on having a fever or having a cough, for example, is not going to accurately capture the number of individuals who are actually infected at the facility and who could be spreading it at the facility. And so that has been a second piece, when there are practices in place where the staff is not being tested and or the prisoners are only being tested when they're symptomatic, has been critical. And the third piece is looking at the authorities that the defendants themselves, whether that be the county officials or the federal officials or the state officials, to actually utilize those authorities to decrease the population. Where they have not done so, can that be used to show deliberate indifference? And collaboration between attorneys and public health, both academics and clinicians, is really key in these areas. And I'll get back to that in a moment, but I think that has really been the main structure of the legal actions that I'm about to speak with you about today. So in the cases that have gone up, where there have been victories, that can take a bunch of different forms. It doesn't always look the same ways in terms of what kind of relief we've been getting from the courts. So one example is an early case that CPCS, which is a public defender here in Massachusetts, as well as the Massachusetts Coalition for Defense Attorneys here at MACDL in Massachusetts, and the ACLU is representing MACDL, brought before the Supreme Judicial Court, which is our state Supreme Court, asking for relief to again decrease the population, utilize authorities so that the population can be decreased at both our state and county facilities to allow for social distancing. And the relief that was provided there was twofold. One was a presumption of release for certain individuals who are being held pre-trial. So it wasn't an automatic release, but there was a hearing that is available to individuals if they're being held pre-trial, and the court input a presumption that those individuals be released as a result of the pandemic, and that would have to be overcome by the government if they were going to be held in. The second piece was reporting requirements so that we could continue to keep track of the spread of the pandemic at the facilities in Massachusetts. And that included tracking the number of individuals released as a result of the decision, the number of positive tests, both among staffs and prisoners, and the number of tests of staff and prisoners. And that has been really critical in terms of tracking where there are hotspots within the facilities, where we're seeing outbreaks. At the moment, and this is updated as of yesterday, in Massachusetts, there are 534 confirmed positive prisoners and 309 confirmed positive staff members. In terms of the number of tests that have been done for prisoners, there have been 5,121. I think that's actually a really critical number because it can show what the trend has happened as we've continued to report. Just 1 month ago, there was only 540 prisoners who had been tested, but the Department of Corrections at that point instituted a more universal testing approach in terms of who was going to get access to the test, and we've seen that exponential increase in the number of tests as a result. Another form of relief that you can see is getting experts into a facility to try to address the condition. So in the Banks v. Booth case, which came out of DC and had to do with the DC facility, there the court ordered that an independent expert, medical expert, needed to go into the facility, review the conditions there, and make recommendations that ultimately the court ended up ordering be followed in terms of access to hygiene, access to cleaning, the number of times things were cleaning, differences that they needed to make in terms of their physical facilities to allow for social distancing. So that's another way in which we've been able to get relief. What I want to focus on, however, there have been a number of cases that have really addressed that critical issue that I addressed at the start, which is this social distancing and decreasing the population at these facilities, both to protect the individuals who are released, but also to ensure that those who remain are able to more effectively practice social distancing. So for example, and there are a couple of different ways in which that decrease in population has occurred. There are two cases out of this circuit. So the Savino decision, which is here in the District of Massachusetts, and the Gomez decision out of the District of New Hampshire. These both took place within the immigration detention context rather than the sentenced population, but they were similarly being held by county officials. And what the court ended up ordering in both of these cases was, while the case was pending, the court itself was going to conduct individual bail determinations to see whether the individuals could be released while the decision was pending. So the authorities themselves were not being ordered to actually exercise their own authorities, but under the habeas petition and powers of the court was going to conduct bail decisions to decrease the population while the case was pending. Finally, the two cases I want to talk about that have been within the carceral setting that have also used a different mechanism to decrease the population. It's a set of cases. There's the Wilson decision out of Ohio, and that had to do with the population at a Bureau of Prisons facility, Elkton. And then the Martinez-Brooks decision, which is out of the District of Connecticut, and there it's another Bureau of Prisons facility there in Danbury. And the Bureau of Prisons is somewhat, is in a particular situation because of the authority that has been both granted by Congress and directed to use by the Attorney General. There are a host of different tools that the Bureau of Prisons typically has available to it in terms of releasing someone on home confinement. They're still in their custody, but they serve the duration of their sentence or a portion of their sentence on home confinement. There also can be compassionate release where someone is released for medical reasons or otherwise. The CARES Act, which came out very soon after the pandemic hit here in the States, Congress authorized a decrease of the limitations. There are typically statutory limitations on BOP's ability to exercise home confinement that has to do with the percentage of the sentence that is left. The CARES Act took that away, or said that those limits would not apply if the Attorney General made a finding that there was an emergency situation that was impacting the management of the Bureau. And the Attorney General, in turn, very soon after, issued a memo to the Bureau of Prisons on April 3rd, making that finding that there was an emergency decision and directing the Bureau of Prisons to use its home confinement authority as one of its tools to combat the spread of COVID-19. Nevertheless, the Bureau of Prisons has implemented its own self-imposed requirements, including percentage of sentence that has been served, which has basically meant that at most of these facilities, individuals are not being released on home confinement. And as a result, there have been arguments made in the Wilson case and the Martinez-Brooks case that were accepted by the court that the Bureau of Prisons' failure to use its own authority available to it to decrease the population in the face of this pandemic is an indication of deliberate indifference. And the court in both of those cases has ordered the Bureau of Prisons to use its own authority to release individuals under home confinement or furlough or compassionate release, and then come back to the court with anyone that it's not releasing under those authorities so that that can be reviewed by the court and by the parties themselves. So there's a suite of different ways in which this has been addressed in the courtroom, but I think something that's been consistent throughout it all and that I really want to emphasize here, and hopefully we can get into in the Q&A, is the critical piece of collaboration between attorneys and public health experts, both academics and clinicians. I can lay out the law for a court when I'm sitting there arguing, but what's really critical is that we have individuals and experts who can educate both the attorneys and the public and the court system about the spread of the disease, the importance of testing, the importance of social distancing, how asymptomatic transmission works, the degree to which this impacts not just the internal facility itself, but the surrounding community and the surrounding hospitals. We've had the great good fortune to be working with public health experts, including Karthik, in some of the cases that we have worked on to submit declarations to the court or amicus briefs, friend of the court briefs to the court to make some of those points, as well as to speak to the public and the media to get this information out there so we have a broader understanding. So one of the things I think as we look towards what are the next steps in this pandemic, is that we should look to ways in which we can help to build those relationships and continue those relationships. I know it has been incredibly important in these first 2 months. I think that will become all the more important as we're beginning to see states relax some of the requirements in terms of stay-at-home orders for the general population. We know that the same dangers, however, continue to exist within jails and prisons. Having the experts be able to explain why this is still an emergent situation in carceral settings, why we need to have action, is going to be critical. It also provides the opportunity to look for other areas where we know there's a public health narrative when it comes to the way in which we are treating and working with the carceral population in our states. And so looking for additional opportunities, even outside of the COVID-19 pandemic response, to work across these silos and really break down those silos and use a public health narrative that really is so core to the way that we should be thinking about how we operate as a carceral state, is a silver lining of an opportunity that I hope that we're going to be able to build upon as we continue to move forward.
Well, thank you so much, Jesse. That was a really excellent synopsis of, what the kind of landscape of this problem is, and you've covered everything from social distancing um, to testing to treatment. So I think that really is a great start and a great lead in to our next speaker, Kartik, who's going to talk a little bit about some of the public health issues from the medical standpoint. So Kartik, I'm going to hand it off to you.
Thank you, and Jesse, that was really amazing, and just so impressive the work that you're doing and others are doing to advocate for these issues. So I'm actually going to ask us to take a step back a little bit and just to take a moment to reflect on how COVID-19 is happening within a greater historical context, and that historical context matters. So maybe just to start, I want to give some data. And so this is showing rates of COVID-19 deaths by race and ethnicity. It's only as of May 4th, but the pattern really hasn't changed that much. And you can see here, for example, that our Black residents are dying at much higher rates than our white residents. And this video is showing something similar, which the orange are the disproportionately Black counties that have been affected, and the blue are all other counties. And the numbers to pay attention to are really right here. And as you'll see over time, that there's been a huge impact in terms of our Black communities of COVID. And so then as of May 10th, we see that 48% of cases and 55% of deaths are in the 22% of counties that are disproportionately Black. And the important thing here is it's not that these communities are not taking it seriously. In fact, it's quite the opposite. So this is Pew Research data, and it's basically asking two questions. The first question is, are you worried that getting COVID-19 will require hospitalization? And if you look at the answers, we actually see that communities of color, Black and Hispanic, were more worried early on, this is in April, about getting hospitalized. And we see the same pattern playing out with lower income groups. And then in terms of being worried about unknowingly spreading COVID-19 to others, once again, the same pattern. Communities of color, more worried than white communities, and lower income communities are more worried than upper income communities. So if it's not that they're not worried or not aware, then what's happening here that these communities are getting disproportionately impacted? So this is really where the broader context matters. And so this is basically a picture of American history. And you can see that essentially only 16% of the last 400 plus years of American history have not been in times of either slavery or Jim Crow. I'm just going to pause and let folks just absorb that for a moment. And then in the modern era, the post-Jim Crow era, we see that there's still other problems, and that includes the war on drugs and mass incarceration. So, I guess the question is really, should we be so surprised that certain communities are getting hit harder than others? let's look at a few more examples and get a little bit more detailed. So this is healthcare. Historically, we have a history of unethical medical experimentation. The Tuskegee experiment's a great example of many. That has led currently to medical distrust among our communities of color. And that manifests in the COVID-19 pandemic with lack of trust in hospitals and providers around goals of care, around visitor policies, around access to ventilators and who's going to get access. In the criminal justice space, we see the school to prison pipeline, and Jesse spoke really eloquently about some of the issues here. And so we see that, for example, a Black person's 20% more likely to get sentenced for the same crime and will spend 19% longer in jail for the same crime. And so we see the numbers of 1 in about 106 white men in jail as opposed to 1 in 15 Black men in jail. And kind of getting back to what Jesse was pointing to, so these are confined and unsanitary conditions that have a lack of ICU level care. And so once again, we see this differential infection rate and mortality. What about if we look at economics? And to be clear, this is an extremely oversimplified picture. I'm not even trying to capture the complexity. This is more just to illustrate the idea. So employment discrimination and other structural inequities leading to wealth gaps. So in Greater Boston, white family has an average wealth of about $250,000 as compared to $8 for a Black family. And then the impact is that we see our essential low-wage jobs tend to be occupied by low communities of color, and they tend to be the same ones who are hired last and fired first. They may not have the resources to quarantine, and then once again we see these differential infection rates. And then in terms of housing, we have a long and storied history with housing discrimination, and so there's a homeownership gap, and white families have about 73% homeownership as opposed to 44% for Black families. And that makes it really hard to isolate. It makes public transportation difficult. You might have to commute further to get to work. And so once again, we see these differential infection rates. And with this one in particular, this is actually a map of Boston. It's not all the neighborhoods, but it's a lot of the neighborhoods. And this heat map basically shows where COVID-19 is having the biggest impact. The darker purple here are areas with higher rates of COVID-19 infection. And they're communities like East Boston, Dorchester, Mattapan, and Chelsea. Well, this is not accidental, this map. So if you actually look at a map of Boston from the 1930s, it looks very similar. So there was this practice of redlining in the 1930s whereby the homeowners loan corporation would grade neighborhoods and basically draw a red line around neighborhoods that they thought were unsuitable for lending. And essentially they had this, you can see A through D system, best, still desirable, definitely declining, and hazardous. This is Chelsea, for example, is an actual picture from that map. And it says that Chelsea is characterized by detrimental influences in a pronounced degree, undesirable population, or an infiltration of it. And so they're refusing to make loans in these areas or on a conservative basis. And then it says, for example, respectable people, but homes are too near Negro area. And so the availability of mortgage funds is none. And so what we see then is that Joe's family, his great-grandfather was able to access funds at a low interest rate to buy a house, and that home ownership has then passed down over generations into wealth. But Jamal's family did not have that opportunity. And that's how we build most of our wealth in this country, is actually home ownership. And we still see that woven into our home deeds across America. This is an example of a home deed saying that the said premises will not be rented, leased, or conveyed to or occupied by a person other than of the white or Caucasian race. This is actually common to thousands of home deeds, and it's actually pretty expensive to get rid of them, and there's resistance. But this is a remnant of that history that we have of redlining, and there's still differential access to funds for home mortgages and so on. So getting back to the question of why are we seeing differential impacts of COVID-19, I mean, it's all of these different factors. It's this the history of structural inequities with economics, with neighborhood and physical environment, with education, with food, with our healthcare system. But really what we're talking about is the same thing with all of these. It's structural racism, classism, and other forms of structural discrimination. And the problem has been that we're very fragmented. So in healthcare, we'll talk about health disparities. In juvenile justice, we'll talk about disproportionate minority contact. In education, it's the achievement gap. But once again, at the end of the day, we're all talking about the same thing. And until we start talking about it and approaching it as the same thing, i.e. structural racism, and then coming together to work on it, we're not going to make a ton of progress. So let's look at healthcare then. And these are health outcomes. This is just a few examples, but pretty much across every outcome, you'll see a similar pattern. This is Black versus white, and it's heart disease mortality, female breast cancer mortality, stroke mortality, very low birth weight, infant deaths, maternal deaths. And so you see, over and over and over again, this difference in life expectancy that is inequitable, i.e. it's systematic, it's unjust, and it's preventable. And, when COVID-19 was starting to unfold, there was a lot of, surprise that people were expressing around the fact that it was impacting certain neighborhoods harder. But if you actually look at this, it shouldn't be surprising at all. We can predict exactly what's going to happen. And that's what we see, that there's a differential rate of mortality, once again, by race. And it's not just affecting Black communities. So this is data from Partners Healthcare. And it's showing, for example, some data for ethnicity. So Hispanic, we see that our Hispanic patients are testing positive at much higher rates. Our non-English speaking patients are testing positive at much higher rates. And you can see here, once again, the same pattern of Black, others probably a mix of different groups, but testing positive at higher rates. So what was our response? The crisis standards of care were released recently in the last few months. Some of you guys may be familiar with it. It's essentially trying to allocate scarce resources like ventilators in the state of emergency. And this is actual language from that crisis standard of care. And as you can see, it's basically saying, actually, I'm going to let you read it for just a moment. So as you can see, it's basically saying that, all these different factors like race, gender, language, including incarceration status, are irrelevant and not to be considered by providers making allocation decisions. And essentially, it's this colorblind approach. It's saying we are now at a moment where we have a scarce resource and we're going to allocate it. But to be fair, we're going to completely ignore the entire history of injustice that we know have impacted certain groups and make the decision just as a snapshot. This is another way of kind of showing what we're doing there. And it's this sort of colorblind approach that ends up perpetuating inequities. This is the analogy here is it's like a river, and the structural inequities are current. And doing things in a colorblind, neutral sort of way is not going to stop or reverse these inequities. It's going to actually perpetuate it. And so what we really know is that it's up to the lottery of life. Where we're born, grow, live, work, age, that's going to determine to a large extent how we die. And actually 70 to 80% of that difference in life expectancy between Black and white Americans is explained by socioeconomic factors. The other important point here is that this sort of colorblind approach doesn't just hurt these disadvantaged communities, it also hurts everyone. And this is getting back to that point of the public health impact. So we know that 12% of the 2.3 million people currently in state and federal prisons are over 55. That's 3 times more than in 1999. And so it's a bit like this picture here. I don't know if anyone's seen this cartoon, but in this case, the folks in the bottom deck are our prisoners who are in overcrowded conditions with poor ventilation and smoking and physical, sexual violence, psychological isolation, poor sanitary conditions, lack of ICU. And a lot of us go through our lives thinking, well, that's them and we're not going to get impacted by it. But the reality is if there's a huge outbreak among this prison population, these are the same prisoners who are going to then show up in our hospitals and will be competing for resources. And so once again, incarceration status will make a huge difference here. And it might be, even with a colorblind approach, that you end up not getting a ventilator because we haven't taken care of our disadvantaged populations behind bars. So to kind of summarize, race, class, other factors determine how and when we die, and actually if we will die in jail. So at the patient level, whether a person's going to experience barriers to care, whether a request will be perceived as a request or as a demand, whether we're going to actually give them time for managing things like pain. We know there's huge inequities around pain management. whether we're going to give them access. Are they going to go to a safety net hospital that's under-resourced or an academic medical center, or are they going to be getting whatever healthcare they can get in the prison system? Are they going to have access to resources? Are they going to get access to specialty care? There was a study that came out at the Brigham showing that our Black patients tend to get differentially referred to general medicine, while our white patients get referred to the cardiology service for heart failure, an example of implicit bias. It determines whether folks are going to trust or fear the system and whether we're going to trust or fear them. It determines whether you're going to have cultural understanding. If you're part of the majority culture, it's easy to get cultural understanding. If you're not, it's very difficult. And whether you're going to have your language preferences respected. And then, of course, there's bias and racism manifesting as microaggressions and playing out in patient experience. So the reason I've kind of gone over this is it's not just about criminal justice. It's not just about decarceration with COVID-19. It's not just about healthcare. It's about all of these different things. And once you start to see it this way, in the structural way, you start to see that it's a much deeper groundwater problem. And we're not going to get where we need to get by addressing the symptoms. And so decarceration is important. It's also really far downstream. And so we also need to be thinking about what are the upstream things that we can do. And that's not easy. The moment you try to start moving upstream, you're going to find that you're going against the current and you're going against other people. But that's really what we need to be doing. And so here's some examples of things we should start to think about in this work. Number one, naming racism and other structural inequities. Let's not talk about it as just a decarceration issue or just a healthcare issue. Let's talk about it as structural racism playing out in these different spheres. We need to work across disciplines and fields. So, being able to partner with Jesse to submit that amicus brief, that's the type of work that we need. We need folks partnering across healthcare, the legal field, to advance some of these social justice issues. And some things that healthcare folks can do is we can explain the science, we can publish op-eds, we can give expert declarations. There's also a real hesitancy in healthcare to be social justice practitioners. I think the fear is that we're going to be seen as not being objective or that we'll somehow lose credibility. But this leads to some really bad decisions. So for example, some of the best practices with COVID that applied for what we would do with our people in skilled nursing facilities apply to people in jail as well. It's just that the second one is politicized and the first one is not. So you see healthcare institutions taking all sorts of great steps to help our patients in skilled nursing facilities, but then completely ignoring our prisoners. And then we need to consider structural and systemic factors. So we need to think about things like misguided drug laws, harsh sentencing requirements, psychiatric deinstitutionalization. I'm a psychiatrist, and we saw this is a huge contributor to the over-incarceration problem, the for-profit prison and bail industry, and then ultimately centuries of structural racism. So, I think hopefully, this may have seemed like a tangent, but really what I was hoping to do is to get folks to take a step back, to see the bigger picture, and to understand this moment of COVID-19 within the broader context. I think it's been both a magnifying glass and also a mirror. A magnifying glass in terms of magnifying the problems that we already have and have known we've had, and a mirror in terms of being able to reflect on the things that have been going well and that have not gone well. And so when we start to think about the future, when this is all over, when COVID-19 has kind of died away and the next crisis is on the horizon, what should change? The answer really needs to be everything. Everything needs to change. That's from our laws to our policies to our practices. It's embedded everywhere. And so we're going to need some really fundamental changes to get to the place where we need to be. I'll stop there.
Thank you, Kartik. That the discussion around addressing structural inequities is an important one, and it shows the real need to work together interprofessionally to address not only COVID-19 in prisons, but all these other upstream issues that are really at the root of this. And there's a lot of work ahead of us to kind of work together on these problems. So thank you, Kartik. And with that, I'll lead you into our last speaker, Joel Thompson.
Thank you, Stephen. Thank you all for being here and for having me. It was a great presentation, Jesse and Karthik, and really getting at some of the structural issues. And I'm going to get down into a more granular level given the work that we do. But it does, I would agree, COVID has simply brought into relief some things that a lot of people have known have been an issue, have been a challenge, have been a problem for a long time, especially for people in prison. And it's, along with the systemic issues, structural racism and everything else that leads to the incarceration rate we have, you just have the simple treatment of the prisoner as other, right? And in particular, Karthik, the skilled nursing facility versus jail comparison, right, is where that comes into play, that you can justify a lot of mistreatment or neglect once somebody's in the criminal legal system, because, well, then they shouldn't have done that, or they wouldn't be here. And so now that this is their just desserts, and that's a very simplistic view of our criminal legal system and how it works, and who among all of us is responsible for whatever involvement people have in the criminal legal system. So anyhow, just to remind everybody who I am, I'm the managing attorney at Harvard Prison Legal Assistance Project, and our law students are volunteers. It's a student practice organization. It's a student-led organization where they represent prisoners in administrative hearings, disciplinary hearings, parole hearings, commutation petitions, classification hearings, which are where you get housed. And we do some policy work and other work also. And lately we're doing some advocacy around COVID, specifically around trying to get people released, either released on parole. In some cases, people who had positive parole votes, trying to get them actually out, because the parole vote, even though it says congratulations, also has a bunch of conditions that the prisoner can't hope to meet by himself or herself without some help, or to see into the future, and often into the near future. We have clients who are due to get out of prison later this year, and to say, why don't we find ways to award them some sentence deductions and get them out now, with an appropriate release plan, and decarcerate and be able to distance better in the prisons with the people who remain, and also protect this person's health. We're working on those types of cases as we speak. So far, they've been more or less unavailing, with a couple of exceptions. I want to talk about it following on Karthik's presentation and Jesse's presentation about the systemic challenges, and her office has done incredible work, and the ACLU around the country has done incredible work, along with many, many other legal advocates, to bring the risk of harm to the court's attention, across multiple states and federal jurisdictions. And that risk of harm is to everybody, right? It's to incarcerated people, and it's to the staff in those facilities, and it's to the people in the community, because the fact is, as opaque as these institutions are, people come and go. And some of Jesse's work has actually brought that to light, as we have seen data be produced in the litigation in Massachusetts to show like what the actual churn is of people coming in and out of the system. And that happens, regardless of whether anybody additional is released because of COVID. People wrap up their sentences, they win a pretrial motion, and they go home. And so there are consequences, for the incarcerated individual, and for his or her family, and for all of us for that. But I want to talk about what the challenges look like to our clients on the ground. And these are Massachusetts prisoners, more or less all of them, some in county facilities, some in the state. The response to the coronavirus and the restrictions being placed on everyone, no one's been immune from that, but it's been harder. It's harder on people in prison. The effect is much more punitive. The Department of Correction in the state is in a lockdown. I think you would see many of the counties, or at least portions of those county facilities, are also in a lockdown to try to prevent the spread of the disease. Well, that's a laudable premise, I guess, but the result is solitary confinement. I mean, that's what that is. So our clients are reporting getting out of their cell maybe half an hour a day. There's some hope that amount of time out of cell is going to come up now. But for weeks and weeks, 6 to 8 weeks, it's been a half hour out of cell per day, long enough to, maybe take a shower, or maybe get some limited form of recreation or walking around before going back in cell. Recreation is more or less canceled. For a lot of people, that means all outdoor time is canceled. Even when you get a little bit of recreation, it might be indoors. All programs and classes were canceled, at least in the state prison system, and I think likewise in the counties in many cases. All visits have been canceled, save for attorneys, most of whom, we're not visiting prisoners because we don't want to spread coronavirus into the prison and put people at risk. So visits are basically shut down. There's limited access to phone. There's limited access to email, especially for those who can afford it, because email means having to have a prison-approved tablet that has to be bought. Even the mail has been slow. You can get mail in and out, but we've noticed a real slowdown in the processing of mail and getting it to and fro. The diet is limited. Staffing has been reduced, and so the diet has changed to sort of bare bones, very repetitive, very least common denominator food. There's actually less access to medical and mental health care, right? Because the focus on COVID-19, which is a real dangerous problem when you're also isolating people and putting them in essentially solitary confinement conditions. I mean, that's what a lockdown looks like. It looks a lot like solitary confinement, albeit with your cellmate in a lot of cases. So living with one other person. And so we are hearing reports of a lot of people decompensating, deteriorating mentally, and they're having trouble getting access to mental health care for that. If you have a medical need that is not COVID-19, that also, is something people are having difficulty getting. And in particular, the two things together, the lockdown and limited access to healthcare, interact really poorly. For example, diabetics, may need to adjust their insulin levels based on their activity level and their diet. Well, the activity level and the diet are changing. And so it's hard to get things just right. And you're dependent on, staff to make that happen for you. Similarly, people with seizure disorders, they also take, generally a lot of them take medications that are really affected by diet and activity level. And that obviously has changed a lot for them. So there are these measures happening in the prison to prevent the spread of COVID-19, but they come with a real overlay of coercion, and control. In our office, early on in the pandemic, we got a call from a client who was going to be disciplined for wearing a mask, because at that point, you were not allowed to do that, and it was deemed to be a security violation, covering your face. When we stepped into the matter, the charges against him were dismissed. But I think soon we will see, disciplinary charges being brought against people for not wearing a mask. What is an advisory out on the street is often, a rule where compliance will be obtained, however they need to do it, including by very punitive measures behind the wall. We also have clients who are being punished for refusal to move from one unit to another, when there's a real information asymmetry there, where they don't know why they're being moved or why someone else is being moved in with them and where that person's coming from, and what precautions have been taken. We're seeing a lot of situations like that, and we'll see more as time goes on, I'm sure. So these restrictions have been hard. Information is really hard to come by. That's always true in a prison setting or a jail setting. I mean, the baseline is these are opaque institutions. There's not a lot of information coming in or out. That's generally, how they like it, and it's generally a real challenge. It generally does not lead to good results. The lack of volunteer or classroom or program staff coming in and out, the lack of regular visitors, whether they're family members or friends or anybody else, coming in and out of the wall, that's a real problem. Exacerbates the problem of information asymmetry and opacity, because if it's an abnormal environment to start with, a jail or a prison, it's not a normal environment. It's a very difficult one. The dynamics between the incarcerated individuals and the staff members is really challenging. Foot traffic to and fro, in and out from the outside world helps, Doesn't solve all the problems, but it helps some. But right now we're not getting that. And so that's a difficulty. Our clients are scared. Those who call us, their families are scared. They have a hard time. They get the occasional memo, they get given a mask and told they have to wear it. They get told they're not going to get canteen this week. They get told, they should clean the phone before they pick it up to call home. They don't get a lot of information about what is going on in the facility, or around them. And that's a difficult thing to grapple with. Without the litigation brought by Jesse's office and others, we wouldn't have any information at all. I mean, the fact that we know today in Massachusetts which county facilities, which state facilities are doing testing, which ones have found, had positive cases for COVID among prisoners, among staff, how many deaths there have been, that information would not have come to light absent legal advocates going to bat for the incarcerated population. And it's great that we have it, but there's more that we ought to know. We ought to know more about what the treatment protocols are like in the prison. We ought to know more about outside hospital utilization and who's being sent out and when. We don't see, for those of you who check in with the daily press conferences of this governor or governors in other states, you will rarely hear mention of the incarcerated population. You hear lots of mention of work being done in other facets of our society, whether it's hospital capacity or treatment of the homeless population. You don't hear a lot about the jails and prisons, and that's a problem. They are siloed. That's just a plain fact, and it's one that's been around for decades. There is, some interaction with public health officials and with the health and human service agencies, but they're typically seen as public safety agencies. They are separate. There's some, communication back and forth, but largely they are left to be independent in how they deal with these things. And if ever there were a time for public health officials to take charge, to be more intimately involved in what we do in our jails and prisons around COVID-19, then this is it. But unfortunately, that does not seem to be happening. And at the end of all that, I guess, what's the bottom line for incarcerated individuals? A lack of information, a very coercive environment right now, even more so than usual. They feel like sitting ducks, right? Like what a lot of things will happen to them and they don't have a lot of agency over it. What are some of the future challenges? I want to just put a few out there going forward from here. When it comes to COVID treatment, as the standards of care evolve, will the standards of care make their way behind the wall into the jails and prisons? They tend to lag behind on that. We've seen it with HIV, we've seen it with hepatitis C. We will likely see it here absent some advocacy and some noise being made in the community about it. Karthik mentioned, pain management. Palliative care is very hard to come by in a prison environment. You're supposed to be punished, right? So that's hard to come by. A lot of the measures meant to prevent the transmission of this disease, will they become permanent? Right? Will all visits turn to being non-contact visits or video visits? Will programs be reduced, right? And classes? Will outdoor recreation be reduced or limited on a permanent basis? Telemedicine, I understand, in some places is being used for mental health assessments and interactions. Is that going to become the standard instead of the exception, which is what it is right now? There's a lot of ifs out there, things that could come out of this even once we're past the pandemic, that could be really problematic for prisoners. I think there's a reckoning here, and it involves responding adequately to the pandemic, but it also involves confronting, as Karthik mentioned, things that we know have existed. In Jesse's litigation, the response from some of law enforcement agencies were, well, we can't let additional prisoners out right now because they don't have anywhere to go. Well, if that's true, which it's not for some, but it is true for some, then whose responsibility is that? And the state has taken a position and the counties have taken a position, well, that's the incarcerated person's responsibility. And I would submit that that's everybody's responsibility. That is a problem that has long been known, that we don't have a comprehensive, logical, rational system in place, even though we know we release hundreds, thousands of prisoners a year, hundreds a week. We don't have a system in place to ensure that they have the support they need, housing, treatment, etc., to get on their feet and reintegrate into society. And here again is an area where public safety does its thing. Public health and healthcare providers, I think there's an opportunity here to step in and say, enough is enough, because we deal with the fallout of this. We see it too, and we see it in our community members. We need to rethink the way we do reentry and release planning for incarcerated people. And I want to stop there. Thank you.
Thank you, Joel. That really puts the boots on the ground view into perspective. I'm sure we'll have an opportunity during our Q&A to address a little bit more of that. We're going to bring all of our panelists back now. We're going to do a short Q&A in the interest of everyone's time, both our panelists and the attendees. So as soon as everyone's unmuted here and our videos are restarted, we'll ask some of the questions that we've been getting through Twitter and through other means. So the first question, and again, in the interest of time, we'll give each of you an opportunity to talk if you'd like, but we'll try to keep it brief, is what metric would you recommend we use for deciding who is going to get released? Should these be strictly nonviolent offenders? Should these be drug offenders? What's the metric that we're going to be using for release of certain incarcerated individuals? So I'll open that up to you as the panel.
Yeah, I mean, I can have, I think I probably should say a little bit about that. What we're seeing in a lot of our litigation, for example, we're right now involved in litigation here in Massachusetts with the federal facility, FMC Devens, which is actually largely a medical center with a small satellite minimum security camp. And I think coming from the public health lens that Karthik really laid out in his presentation, really, I think the appropriate metric for us to be looking at is working with public health officials to make sure that the population is decreased to a certain amount. And when we talk about who it is, that makes everybody safer. Again, that is both providing increased security for the individuals who are being released and also for the individuals who remain within the institutions, because they're going to be able to effectively socially distance, as well as staff and the community. And I think there are two different ways that we're seeing that happen right now in the courts that have been decreasing the population. And first and foremost, if the Bureau, for example, the federal system, if the Bureau of Prisons is exercising its own authority, it can sort of be making determinations about who it's going to be releasing. One potential, as directed by certainly the Attorney General, in terms of one of the discretionary factors to be considering, is medical vulnerability, for example, or a certain age population, because we know that there's increased morbidity for individuals who are 55 plus, and that increases as you get into the 60 and 70 plus. But what we're seeing from courts, and again, you can see this in the Gomez case and the Savino case here in Massachusetts and New Hampshire, is that when the carceral authorities are not using their own authority, there have been some courts that have then stepped in to say, we're going to be making these decisions in a bail determination. And typically the standard of the bail determination is that if an individual has that susceptibility, that the burden is on the government to show that they are at an increased risk of flight or a significant security risk. But outside of that, they're going to be able to be let out on bail while they're a pending decision. So I think it really depends on whether or not the institution in the first instance is going to exercise the tools they have available to them to actually decrease the population to allow for that social distancing, which makes everyone safer. And if not, are there places where the court is then going to step in to do so itself?
Thank you, Jesse. Would either of the other two panelists want to expound on that at all?
Well, only that there's a lot of categories you could come up with for like who should be released and who shouldn't. But one thing to bear in mind, just as an overarching question, is did we get it just right in our criminal system with the person who's incarcerated, who's in front of us? And so like the examples I mentioned, a couple of our clients are very close to their parole date or their release date. And it would be very easy in the absence of any advocacy at all for somebody, a higher up looking at that situation to say like, you know what, close enough. And given the pandemic and given the public health needs, let's move, this category of folks out because they're coming out anyway. It's this fiction that like, these people are never coming out. Like most of them are returning to the community. So can we accelerate that process at all? Yeah.
Oh, great. Another question that we have, again, this is from our Twitter following here, is, how do we ensure that the appropriate resources are going to be available to those individuals when they are released, especially given that, some of them are going to be homeless, there's not going to be much of a job market. And so what are the ways that we can ensure that there are resources for these individuals as they are released?
I know Joel touched on this as well. I think, first of all, I do think it's extraordinarily important to underscore that many people do have homes and resources to go to. And our office is hearing from family and loved ones all the time. I know that, I'm sure that Joel is as well as many other organizations. The idea that everyone who is being released has nowhere to go is just not true. And I think that's really important. And I think the second piece is we're seeing examples of places where resources are being placed. So there have been, communities throughout the country, for example, that have been either using powers of eminent domain or reallocating resources to make dorms and hotel rooms available to individuals who are experiencing housing insecurity, whether that be because they are released from a carceral setting or because there's some other reason that they're experiencing housing insecurity. So it's a matter of resource allocation, but we do have models of how that is working. And I think a second piece we're seeing this, and I also want to underscore this because we've heard this, at least in our litigation quite a bit, is for individuals who are suffering from opioid use disorder. Because of the increased availability of telehealth and the ability to use telehealth, there are resources available for people to have continuity of care for the medication for addiction treatment upon release. And so I think making sure that all of the to my mind, the people who are doing this work are really trying to get the word out to make sure through public advocacy and education that the institutions and the people who are being released know about that, because there are resources available and there are models that we can be following of how to do this successfully.
Great. I think we'll and again, in the interest of time, we're going to wrap up with just one last question. And this again is from our Twitter audience, which is, what can the general public do to help with decarceration? And that could probably also extend to what can, healthcare do to help with that piece as well. And I'll open that up to the panel.
I'll jump in first. To follow up, there's a short-term issue which is tricky, which is why you see organizations running to court and collaborating with healthcare providers to do that kind of advocacy. I think the question will be sustaining that advocacy over the long haul, because this isn't going away, in a few weeks, unfortunately. But also, even once the pandemic goes away, can we achieve some sort of systemic change, some sort of acknowledgement of, all that is wrong or misguided or even just irrational about the way our system works. I was thinking about the previous question. This state mobilized to build out capacity for homeless populations, right now. They built field hospitals. They put a lot of things on the ground and implemented them right away. We need that kind of change for our criminal legal system, for how we deal with people, for how long, or if we incarcerate them, and if they're incarcerated, how we deal with their reentry. But that takes some political will. We clearly have the ability to do it because you can see how it's done, how it has worked with other populations or other initiatives. But we need the political will. So it's a long-term political issue.
Yeah, I think the only thing I might add there is that it's really powerful when the public advocates for something. So for example, if I as an equity leader within the institution say, this is a really important issue, we should move it forward, that might have some sway, but it's even more powerful if the general public is coming up to our leaders to say, why aren't we doing anything to help with our incarcerated population? And so I think just recognizing the power that everybody actually has and write a letter to our healthcare institutions or other areas, and you'll be surprised the type of response you might get.
Yeah, I think if there's anything that's come out of this is really this sense, and I know Karthik, you had spoken about this idea of interconnectivity. I think that's true with respect to both public health and also just the way our systems are all working together. And I remember my office had been involved with some of the work around the travel ban a couple of years ago. And that was really an instance where we saw everyone sort of utilizing different types of skill sets, whether that was in their professional or avocational pursuits, to really bring to bear some movement in this country. And I remember speaking, my husband's an architect, and I was talking to him about the fact that, I'm a civil rights attorney, but we need civil rights doctors, we need civil rights architects, we need civil rights teachers. There is a way in which all of us can use our skill set to really advocate and talk about these issues, because it is so intertwined. I think that's the upshot of all of this being so intertwined. So I really think that there's a role for everyone to play to bring this kind of lens into their work and their conversations to make sure that we're making movement in the right direction.
Absolutely.
Well,
I'd say even another frame on that would be to start to see ourselves as social justice advocates primarily, meaning my role as a doctor is to advance social justice and to improve health and well-being, and your role as a lawyer is to do the same. And so I think it's almost a paradigm shift that we need in terms of, we're not here just to provide healthcare, we're here to actually improve health, and vice versa.
Well, thank you. And thank you to our team at Petrie-Flom, especially Carmel and Chloe, for helping to put all this together. To our fantastic panelists, you've brought some great perspective to this problem. And of course, to all of our attendees, we're very appreciative of you all taking your time to join us today. Please, again, visit our website at Petrie-Flom. There are many other great events coming up. Please visit the Bill of Health blog that is, outlining a lot of these issues as well, and follow us at Twitter at Petrie-Flom. Again, thank you for this engaging discussion that has really revealed a lot of the inequities of our penal system and the impact that COVID-19 has had on this often marginalized population that's being disproportionately affected. My hope is that everyone can take this information and, as you mentioned, become advocates for this population and for this problem. So thank you again, everyone, and we appreciate you joining us today.